In this video, we'll discuss the 12th problem relating to law tort. So, the problem is the plaintiff resided in a house next to a Roman Catholic chapel of which the defendant was the priest, and the chapel bell was sung at all hours of the day and night. What remedies would the plaintiff be entitled to? So, the very facts of the problem are similar to those of the case of Slathu versus D. Hold of 1851 based on Nuisance. These facts of the case are as follows. The plaintiff resided in a house next to a Roman Catholic chapel of which the defendant was the priest, and the chapel bell was rung at all hours of the day and night. It was held that ringing was a public nuisance, and the plaintiff was held entitled to injunctions. Therefore, in the present case, the plaintiff is entitled to an injunction. And now we'll go to the 13th problem. And the 13th problem is that the defendant poured petrol in a drum in proximity of a lighted hurricane lamp in a godown. The petrol caught fire and there was a big blaze which completely gutted the godown, which was led to him for storing grains. Discuss the defendant's liability. The facts of the given problem are similar to those of the leading case, Kothari Jagan Lal versus Nandwan Jayanti Lal, and it was a case decided in 1951, and in this instance case it was held that the defendant was liable for his negligent act for which he was made to pay Rs 12,000 as damages for reconstructing the godown. Therefore, in the present case, the defendant is liable to pay damages for reconstructing the godown. And now we'll go to the 14th problem, and that is the defendant had inserted in a newspaper an advertisement that in a certain form to be let with immediate possession. The plaintiff went down to see the form and incurred expenses in examining the form. The defendant knew that the form was not to be let, but inserted the advertisement only to harass the owner of the farm. Will the plaintiff be awarded damages? So, the problem is based on fraud and misrepresentation, and the facts of the present problem is similar to those in the case of Richardson versus Sylvester of 1973, and the very case was decided under the Queen's bench. In this case, the defendant was inserted in a newspaper an advertisement that a certain farm was to be let with immediate possession. The plaintiff went down to see the farm and incurred expenses in examining the property. The defendant knew at the time he inserted the advertisement that he had not the power to let the farm and that it was not to be let. It was held that this amounted to a false misrepresentation, and the defendant was liable for expenses the plaintiff incurred on this false representation. And in our next upcoming video, we'll discuss the rest of the problems.